Hi everyone, welcome back. This is part 2 of Public International Law Exam Guide full series readout. And the next topic we are going to discuss is intervention, or what is meant by intervention when it is permitted under international law. The term intervention has been defined by Professor Oppenheim in the following words. Intervention is the dictatorial interference by a state in the affairs of another state for the purpose of maintaining or altering the actual condition of things. So, under the international law, in order to constitute interference of one state in the affairs of another state as intervention, the following ingredients must be present. There are three of it. The first one, the interference must be dictatorial, that is by actual force or show of force. 2. The interference should be in opposition to the will of the affected states. And 3. The interference should have resulted in impairing the political independence of the affected state. Now, international law prohibits intervention. However, intervention is permitted in exceptional situations. The following are the interventions which are considered to be legitimate under international law. So, the first one is intervention for self-defense. One state will be justified for its intervention in the affairs of another state when it is necessary for self-preservation. So there is the case here, that is Corfu Channel case, CORFU, Corfu Channel case 1949. In this case, the International Court of Justice held that one state will be justified if it has intervened in the affair of another for self-preservation. In this case, two warships of Britain, while passing through the Corfu Channel, the Corfu Channel constituted a frontier between Albania and Greece. They were seriously damaged by the mines in the Albanian territorial waters. This resulted in damage to the warship and to the death of several persons. After 2 weeks, a unit of British Navy conducted mine-sweeping operation in the Corfu Channel without consent of Albania. A dispute arose between Great Britain and Albania. The matter was referred to the International Court of Justice. The court held that Albania was responsible for damage since she was negligent in not giving warning to the ships, and thus they were liable to pay compensation. By conducting the mine-sweeping operation in the territorial waters of Albania, Britain had violated the sovereignty of Albania, and so they were guilty of intervention not justifiable under international law. This case established the principle that warship of a country can, during peacetime, pass through the territorial waters of another state if the territorial waters from an international passage. The passage should be inoffensive. Article 51 of the UN Charter confers upon every state the right of self-defense, and in exercise of the right of self-defense, a state can intervene on the following grounds. There is 4 grounds. The first one, there should be an armed attack on the part of the affected state. Second, the right exists until the Security Council takes action. Third, it should be reported to the Security Council. Fourth, it should be subjected to review of Security Council. And this is discussed in Article 51 of UN Charter with respect to self-defense or self-preservation of the state. Now, the second instance or circumstance where intervention is legitimate, a state will be justified if it intervenes in the affair of another state to check violation of human rights. The UN Charter gives a place of significance to human rights and fundamental freedom. Under the UN Charter, an individual state can intervene in the affair of other state on the ground of violation of human rights in another state. The UN Charter permits the UN to intervene in the affairs of a state when there is a violation of human rights and that causes a threat to international peace and security. Now, the third circumstance where intervention is justified is intervention in civil wars. As a general rule, the UN cannot intervene in the civil war of any state. But if the civil war assumes such magnitude to pose a threat to international peace and security, the UN may intervene. So that is with intervention. And when there are circumstances where intervention may be considered legitimate or justified. The next topic we have here is state jurisdiction. State jurisdiction is the power of a state under international law to govern persons and property by its municipal law. It includes both the power to prescribe rules and power to enforce them. As a general rule, a state can exercise jurisdiction against person and property within its territory. Under international law, a state can exercise absolute sovereignty in its territory. The territory of a state consists of the land within its boundaries, and if the state is a coastal state, certain part of the sea which are within or adjacent to its land boundaries. A state can apprehend, prosecute and punish a person, whether its citizen or not, if he had violated its laws. The jurisdiction of a state can be broadly classified into two. They are territorial jurisdiction and extraterritorial jurisdiction. Territorial jurisdiction. Territorial jurisdiction refers to the power of the state to govern persons and property within the boundaries of the state. All persons and things within the territory of a state shall or fall under its territorial supremacy, and each state has jurisdiction to govern them by its municipal law. So, in the case that Campania Navarra Vascongado versus Cristinal SS. Campania Navarra Vascongado versus Cristinal SS, that is in 1938. Here, the court held that all the sovereign independent states possess jurisdiction over all persons and things within its territorial limits, and in all causes, civil and criminal, arising within these limits. So that is Campania, Compania, and Navarra, that is Naviera. Then Vascongado, that is Vascongado, Vascongado versus Cristinal SS, Cristinal, Cristinal SS, 1938. Now, a state can exercise criminal jurisdiction within its territory, which includes maritime belt. A person who has committed an offence within the maritime belt is liable to be prosecuted and punished under the municipal law of the coastal state. Now, Chung Chi Chong versus R. We have discussed this case law earlier with respect to state and de jure and de facto recognition. We have discussed this case, Chung Chi Chong versus R. Chung, Chung, Cheung Chong versus R. In this case, the accused was a cabin boy on a board of a Chinese armed public vessel. While the vessel was in the territorial waters of Hong Kong, he was shot and killed. He shot and killed the captain and the chief officer of the ship. The vessel was rushed to Hong Kong and the offender was arrested. The murderer and the murdered were British nationals in the service of Chinese government. The Chinese government claimed extradition of the offender, but extradition was refused. The accused was tried by Hong Kong court and convicted and sentenced to death. The contention of the accused that the Hong Kong court had no jurisdiction to try him was rejected. He went on appeal to Privy Council. The Privy Council held that under international law, a state can exercise jurisdiction against criminals who have committed crime within its territorial waters. Now, subjective and objective territorial principle. Crimes may not necessarily be confined in all their aspects to territories of a particular country. It may so happen that the consequence of a crime which is committed in one country will be in another country. In such situation, country in which the crime is committed can, by virtue of international law, exercise jurisdiction against the offender even though there was no consequence in that country. This is subjective territorial principle. Under international law, the country in which consequence ensued can also exercise jurisdiction, and this is objective territorial principle. A leading case on the extraterritoriality of criminal jurisdiction is S.S. Lotus case of 1927. S.S. Lotus case 1927. The facts of the case are as follows. In 1926, in the open sea or the high sea, a French mail ship named SS Lotus collided with a Turkish ship named Bohakot. The Turkish ship sank and resulted in death of several persons. The collision was resulted due to the negligence of the master of SS Lotus. When SS Lotus reached Constantinople, Damons, the master of the ship, who was a French national, was arrested and criminal proceedings were started against him according to the law of Turkey. Damons argued that the Turkish court had no jurisdiction to try him. The court rejected his contention and convicted him. The French government protested against the act of Turkey and claimed that Damons should be released immediately. The Permanent Court of International Justice gave its decision in favor of Turkey. The court laid down the following principles. There is 3 of them. The first one, no state can exercise jurisdiction over the territory of another state. Second, under exceptional circumstance, a state can exercise jurisdiction over an act which has taken place outside its territory. 3. A state can exercise jurisdiction over crimes committed in foreign country if the consequence of the crime has resulted in the first country. Though a state can exercise jurisdiction against person and property within its territory, a state may not be able to exercise jurisdiction against the following persons and properties. We have 5 of them. The first one, diplomatic agents. Second, foreign sovereigns. Third, international organizations. Fourth, property of foreign sovereign. Then fifth one, foreign troops. Now, extraterritorial jurisdiction. Extraterritorial jurisdiction of a state refers to its power to exercise criminal jurisdiction against a person who has committed crime in another country or beyond its territorial limits. The general rule is that a state has no jurisdiction against a person who has committed a crime in a foreign country or beyond its territory. However, a state may exercise criminal jurisdiction to prosecute and punish its citizen who has committed a crime beyond its territorial limit. A state may also exercise its criminal jurisdiction against a person who has committed a criminal act on board of a ship or aircraft registered in that country, even though the ship or aircraft was lying beyond its territorial limits at the time of the commission of the crime. So that is with the jurisdiction and the 2 types of jurisdiction, and we have 2 theories of jurisdiction under territorial jurisdiction, that is subjective territorial jurisdiction and objective territorial jurisdiction. The next topic that we have here is duty not to exercise sovereignty in another state. Under international law, a state can exercise absolute sovereignty in its territory. A state can apprehend, prosecute and punish a person, whether it's a citizen or not, if he had violated its laws. If a person violates the law of a country and escapes to another country, the state whose laws are violated cannot send its agents or police to a foreign country and arrest or apprehend the person. If a state violates this principle, it would be violation of international law. Now, Berthold Jacob's case. In this case, one Berthold Jacob, a German refugee journalist who was living in Switzerland and was kidnapped by Nazi German agents and detained in Germany. Switzerland protested against the violation of its independence and demanded the return of Jacob. It was held that Germans had to return Jacob to Switzerland. Now, another one is Corfu Channel case. Here, the International Court of Justice held that territorial sovereignty of a state should not be violated by another state. The mine-sweeping operation of England in maritime belt of Albania was held to be violation of this principle. So that is with the duty not to exercise sovereignty in another state. The next topic we have here is state territory. State territory may be defined as the portion of a globe which is subject to sovereignty of a state. A state without territory is not possible. Even though the territory is very small, there can be a state. For example, Vatican City. A wandering tribe, although it has a government, is not a state until they are settled down in a territory of its own. The territory of a state comprises not only of its land mass, but also its national waters such as rivers, lakes and bays, and the territorial sea. Beyond inland waters, the sovereignty of a coastal state, that is littoral state, extends to maritime belt or territorial waters and airspace above its land and water territory. Besides territorial waters, The coastal state also exercises sovereign rights for certain limited purposes over continental shelves, exclusive economic zone and contiguous zone. For example, the law of sea. Now, with respect to rivers, Oppenheim classifies rivers into the following categories. That is, national river, boundary river, non-national river, international river. So, national river, a river which lies wholly within the boundaries of one and the same state is known as national river. A state can exercise absolute sovereignty over its national river. Now, boundary river. The river which separates two different states from each other is known as boundary river. The general rule is that if the boundary river is non-navigable, middle of the river is a boundary and the riparian states can exercise sovereignty on each part of the river as they own. If the river is navigable, then the middle of the river need not be boundary. It would be the middle of the deepest navigable channel in the river. It is known as the talweg. The riparian states can regulate navigation on such part of these rivers as they own. Now, the third category is non-national river. The river which runs through several states are described as non-national river. Such rivers are owned by more than one state. Each state owns that part of the river which runs through its territory. And the fourth kind is the international river. The rivers which are navigable from the open sea and run through several states between their source and mouths are called international rivers. They are termed international because freedom of navigation in time of peace on all such rivers for merchantmen of all nations is recognized by customary international law. A riparian state cannot alter the natural condition of the international river to the disadvantage of other states. A state is not only forbidden to stop or divert the flow of a river which runs from its own territory to a neighboring state, but also prohibits from using the water of the river in such a way as to cause danger to the neighboring state. Now, different modes of acquisition and loss of territory. A state can acquire territory by following methods, that is occupation and prescription, accretion, cessation, annexation, lease. So, these are the 6 ways where the territory can be acquired. Once again, occupation, prescription, accretion, cession, annexation, lease. There are 6 modes of acquisition. So, occupation is one of the modes of acquiring territory by a state. If a state discovers a new territory which is not under the sovereignty of another state and exercises sovereignty, the territory will become the part of the state by occupation. Occupation is possible only in the case of a terra nullius, that is territory not owned by any state. If a state which had been exercising sovereignty over a territory has abandoned it and another state exercises sovereignty over that territory, the territory will become territory of the state which is at present exercising sovereignty. We have a case here, that is Island of Palamas arbitration case. In this case, there was a dispute between America and Netherlands over the islands of Palamas. This island was discovered by Spain. On the other hand, Netherlands occupied it since 1700. America claimed island of Palamas on the ground that they acquired it under the Treaty of 1898 with Spain. The court held that the island of Palamas was a part of the Netherlands because although it was discovered by Spain, they never occupied it and established sovereignty over the inhabitants of the island. In order to constitute occupation of a territory, 2 things are essential. They are 1. An intention to establish sovereignty over the territory. 2. Actual exercise of sovereignty. Mere discovery and hoisting of flag would not by itself constitute occupation. In another case, that is Eastern Greenland case, here the decision was made by Permanent Court of International Justice, where PCIJ laid the following test, that is a 2 test. The first one, in order to constitute occupation, it is necessary that there must be an intention to act as sovereign over the territory concerned. And the second one, there should be some actual exercise or display of such authority. The facts of the case, that is Eastern Greenland case. On July 10, 1931, Norway declared her sovereignty over the eastern part of Greenland through a government decree. Denmark, who claimed her sovereignty over the said area. During the Second World War and afterwards, several Allied powers had declared that the whole Greenland was of Denmark. The PCIJ decided that eastern part of the Greenland is under the sovereignty of Denmark. The court held that a claim for sovereignty based upon the continued display of authority involves two elements and both should be shown to exist. There are the intention to act as sovereign and some actual exercise of display of sovereignty. Now the second mode of acquisition of territory, that is by prescription. Prescription is another mode of acquiring territory. In other words, of Stark, title by prescription is the result of peaceful exercise of de facto sovereignty for a very long period over a territory subject to the sovereignty of another state. Under international law, there is no fixed period for acquiring territory by prescription. A state can acquire territory by prescription in the following conditions are satisfied. That is 4 conditions. The first one, the state should actually exercise sovereignty over the territory of another state. The second, the sovereignty should be exercised peacefully and without interruption. The third, sovereignty should be exercised openly. And the fourth, sovereignty should be exercised for a long period. Now, the third form of mode of acquisition of territory is by accretion. When a new territory is added through natural process to the territory already under the sovereignty of the state, accretion occurs and the added territory becomes the territory of the state. The fourth mode of acquisition of territory, that is cession. When a state voluntarily gives its territory to another state, the other state becomes the sovereign of that country. In Re-Berubari case, the Indian government ceded its territory to Pakistan and Pakistan had given some parts of its territory to India. Now the fifth mode of acquisition of territory is annexation. A territory may be acquired by annexation. Annexation refers to the acquisition of a territory after the conquest. The country which conquered the territory should actually exercise sovereignty. This mode of acquisition is illegal after the commencement of the UN Charter. A recent example of annexation is the annexation of Kuwait by Iraq. After annexation, Iraq declared Kuwait to be its 19th province, but the Security Council of UN declared the annexation of Kuwait as well as the said declaration of Iraq as null and void. Kuwait was subsequently freed by collective action. Now, the sixth mode of acquisition of territory is by lease. Lease is another mode of acquiring territory. A state may lease a part of its territory to another state for a definite period. During the lease period, the lessee state can exercise sovereignty over the leased territory. So, that is with the sixth mode of acquisition of territory. Now, we have laws of territory. So, we have 5 modes through which there is laws of territory. That is cession, then by operation of nature, then subjugation, prescription and lease. So, cession, a state may lose its territory by cession. Then we have by operation of nature, that a state may lose its territory by operation of nature. Then subjugation, a state may lose its territory by conquest. Then we have prescription, a state may lose its territory where another state occupies it and actually exercise sovereignty for a long period. That is prescription. And then lease, when a state leases its territory to another state for definite period, the state loses the territory during the lease period. So that was with territory and modes of acquisition and laws of state territory. The next topic we have is international servitude. Oppenheim defines the state servitude as the exceptional restrictions made by the treaty on a territorial supremacy of a state by which a part or whole of its territory is in a limited way made perpetual to serve a certain purpose or interest of another state. That is servitude, international servitude. Thus, if a state is obliged under a treaty to allow passage of troops of a neighboring state through its territory in the interest of the neighboring state, there is servitude. The state which allowed to use its territory cannot fortify its boundaries for facilitating the passage of the neighboring state's troops. The following are essential characteristics of servitude. There are 4 characteristics. The first one, it is an exceptional restriction. Second, the restriction is created under a treaty. Third, it is a restriction on the territorial supremacy of a state. And the fourth one, as a result of this restriction, the whole or a part of the territory of one state is made to serve perpetually certain purposes or interests of another state. International servitude are classified into 2 heads, that is positive servitude and negative servitude. Positive servitude, it is that which entitle one state to perform certain acts on the territory of another state. Then negative servitude, it is that which creates an obligation on one state to abstain from doing certain act on its own territory for the benefit of another state. Now we have a case here, that is right to passage over Indian territory case of 1960. Here the International Court of Justice recognized a customary right of passage of Portuguese civil person, civil officials and goods over Indian territory between them and certain Portuguese enclaves. However, the court held that such a right is not a general right, being inapplicable to armed force, armed police and arms and ammunitions. The court also held that the right was hardly a servitude in the strict sense, as the right was subject to regulations and control by India. So that is with international servitude, and the 2 types of servitude, that is positive servitude and negative servitude. The next topic we have is 5 freedoms of air. A state can exercise sovereignty not only over all the land within its territory but also over the airspace. There are several theories regarding the sovereignty over the airspace. According to one view, each state exercises control over its airspace up to an unlimited height. It is entitled to exercise complete control over it and may not permit the entry of aircraft of other states in this area. According to another view, each state exercises control over the lower strata of the airspace and its sovereignty is limited only to that extent. Because of this conflict of views, some international conventions were convened and definite rules of international law have been evolved. The most important of them are the following. The first one, Paris Convention of Aerial Navigation 1919. Then Warsaw Convention of 1929. And the third one, Chicago Convention on International Civil Aviation, that is in 1947. So the first one, Paris Convention of Aerial Navigation 1919. Then Warsaw Convention 1929, and the third one, Chicago Convention on International Civil Aviation 1947. According to the Paris Convention, each state exercises complete sovereignty over the airspace. This convention recognizes freedom of innocent passage of aircraft of a state over another state's airspace during peace. The Chicago Convention 1947 is the most important convention regarding the aerial navigation. This convention recognized the following principle, that is, 1. Every state has complete and exclusive sovereignty over the airspace above its territory. Second, no state aircraft of a state shall fly over the territory of another state without authorization by special agreement. And the third, the convention declared the following 5 freedoms of the air. So that is in Chicago Convention of 1947, that Chicago Convention on International Civil Aviation 1947. The first one, a civil aircraft of a state has freedom to fly across the foreign territory without landing. The second one, a civil aircraft has freedom to land for non-traffic purposes. Then third, a civil aircraft has freedom to disembark in foreign territory traffic originating in the state of origin of aircraft. Then the fourth, a civil aircraft has freedom to pick up in any foreign country traffic destined for the state of origin of aircraft. And the fifth one, a civil aircraft has freedom to carry traffic between the 2 foreign countries. So that is with 5 freedom of airspace. The next topic we have is piracy or piracy jure gentium. The law relating to piracy was codified in Geneva Convention on the High Seas 1958. The term piracy is defined as follows: any illegal act of violence, detention, or any act of depredation committed for private ends by the crew or passengers of a private ship or private aircraft and directed a. on the high seas against another ship or aircraft or against another person or property on board such ship or aircraft, or b. against a ship, aircraft, persons, or property in a place outside the jurisdiction of a state. The following are the essential elements of a piracy. 1. Violence of robbery at high seas must be for private ends. Such acts committed by warship, government ships, or aircraft cannot be called piracy. The second, illegal acts of violence, detention, or any act of depredation committed must be by the crew or passengers of a private ship or private aircraft. The third, illegal acts of violence, detention, or any act of depredation must be on the high sea or in a place outside the jurisdiction of a state. And 4. Such act must be directed against a ship, aircraft, persons, or property. In Piracy Jure Gentium 1934. In Piracy Jure Gentium 1934, the court held that committing of actual robbery is not essential for piracy. Even an unsuccessful attempt to commit robbery at high seas will also constitute a piracy under international law. Piracy is considered to be a crime against mankind. A pirate is treated as an enemy of mankind, hostis human generis. A person accused of committing the crime of piracy may be apprehended and punished by any state by exercising universal jurisdiction. So that is with piracy or piracy jure gentium, and the case is in 1934. The next topic we have is law of the seas. The international law relating to the sea is contained in the UN Convention on Law of Seas 1982. The following are the rules with regard to the sea. The first one, maritime belt or territorial waters. A coastal state can exercise sovereignty over some part of the sea which is called maritime belt or territorial waters. Up to the 18th century, the cannon shot rule was prevailed. According to Binkershock, the breadth of maritime belt extends to that distance where a cannon can fire. Up to 19th century, the range of cannon shot was generally 3 miles. In 19th century, 3 nautical mile was recognized as the breadth of maritime belt. In the first half of the 20th century, 3 nautical mile rule had been accepted by the states. But in the second half of the 20th century, different states claims different width of territorial waters. The Geneva Conference on the Law of Seas 1958 made an important attempt to fix the width of the maritime belt, but no agreement could be reached. Now, India claimed territorial waters up to 6 miles through a presidential proclamation in 1956. In 1976, India extended its maritime belt to 12 nautical miles. The controversy finally ended with the adoption of UN Convention on the Law of the Seas in 1982. According to the Article 3 of the Convention, the breadth of the territorial sea. The controversy finally ended with the adoption of UN Convention on the Law of Seas 1982. According to Article 3 of the Convention, the breadth of the territorial sea is 12 nautical miles measured from baseline. The Anglo-Norwegian fisheries case that came in 1951. In this case, a dispute arose as to the delimitation of territorial waters. The Norwegian government, by a decree, defined its territorial waters. In order to fix a baseline, they have selected 48 points on the mainland or on island or rocks at a considerable distance from the mainland. The result of the decree was to include large stretches of sea, including coastal indentation, which normally would have been open sea, in which other states would have been entitled to fish. Great Britain challenged the validity of the decree on the ground that it was contrary to the international law. The dispute was referred to the International Court of Justice. The International Court of Justice held that the delimitation of territorial water by reference to baselines comprising of points on the mainland and the islands and the rocks is not contrary to international law. However, the drawing of the line should be reasonable, just, and not arbitrary. It was further held that a coastal state is entitled to exercise exclusive sovereign right over the territorial waters. Right of states over territorial sea. A coastal state is entitled to exercise sovereign right over the territorial sea. However, a foreign merchant vessel has the right of innocent passage through the territorial waters of a state. A coastal state must not hamper innocent passages through the territorial sea. The coastal state is required to give appropriate publicity of any danger to the navigation within its territorial sea if it has knowledge. The Corfu Channel case. The International Court of Justice held that even a foreign warship can pass through the maritime belt of a state during time of peace. However, the passage should be innocent. A passage is innocent so long as it is not prejudicial to the peace, order, or security of the coastal state. A foreign submarine should navigate on the surface when it passes through the maritime belt of the country, and it has to show its flag. The second is contiguous zone. Contiguous zone is that part of the sea which is beyond and adjacent to the territorial sea of the coastal state. The contiguous zone may not extend beyond 24 miles from which the breadth of the territorial sea is measured. In other words, it is 12 miles beyond the territorial sea. According to Article 53 of the UN Convention on the Law of the Sea 1982, in contiguous zone, the coastal state may exercise the control necessary to a. prevent infringement of its customs, fiscal, immigration, or sanitary regulation within its territory or territorial sea. B. Punish infringement of the above regulations committed within its territory or territorial sea. So that is with respect to Article 53 of UN Convention on the Law of the Seas 1982. Now the third is continental shelf. The construction of a sea is such that when we proceed seaward, it becomes more and more deeper, and a place where sea becomes steep. The land mass and deep sea is separated by a shelf or terrace. This terrace portion is known as continental shelf. The width of the continental shelf may be several hundred miles. The concept of continental shelf has got world attention by the Declaration of Truman, the US President, in 1945. By the proclamation, USA declared that the resources of the continental shelf contiguous to a USA would be subject to its jurisdiction and control. The declaration is popularly known as Truman's Proclamation. That was in 1945. The UN's Convention on Law of Sea 1982 defined continental shelf as the seabed and subsoil of the submarine sea throughout the natural prolongation of the continental margin or to a distance of 200 nautical miles from the baseline from which the territorial sea is measured. Over the continental shelf, the coastal state has sovereign right for the purpose of exploring the seabed and exploiting its natural resources. No state shall explore or exploit natural resources in the continental shelf of another state without express consent of the coastal state. The coastal state shall have the exclusive right to authorize and regulate drilling on the continental shelf for all purposes. The coastal states are entitled to construct and maintain installations within their continental shelf for the purpose of exploration and exploitation. However, proper warning should be given to the existence of installations for the safety of navigation. The right over the continental shelf is an inherent right. And the fourth zone is exclusive economic zone or patrimonial zone. Patrimonial sea. The concept of exclusive economic zone was the first time advocated by Kenya in 1972 at the Geneva session of the UN. The UN Convention of the Sea on 1982 gave legal recognition to the concept of exclusive economic zone. It is 200 nautical miles from the baseline from which territorial waters is measured. In the exclusive economic zone, the coastal state shall have a. Sovereign authority for the purpose of exploring, conserving and managing the natural resources of the seabed, subsoil and superjacent water. Now, B. The right to establish and use artificial islands and structures. C. Right to conduct marine scientific research. D. Right to protect and preserve the marine environment. In exclusive economic zone, all states have the freedom to navigate and overflight and of the laying of the submarine cables and pipelines. All states shall give due regard to the laws and regulations adopted by the coastal state with regard to its exclusive economic zone. Now, the fifth zone is the high seas. The earlier view was that open sea or high sea is a sea outside the territorial waters. In the modern period, the concept of high sea refers to that part of the sea which is beyond the exclusive economic zone of a coastal state. The high seas are the common heritage of mankind and are not within the property of any state. All states are free to use it. Every state, whether coastal or landlocked, has the right to sail ships flying its flag on the high seas. The UN Convention on Law of the Seas 1982 recognized the following freedom of the high seas, that is 5 freedoms: freedom of navigation, freedom of overflight, freedom to lay submarine cables and pipelines, freedom of fishing, freedom of scientific research. The high seas shall be reserved for peaceful purposes. A state cannot claim sovereignty over any part of high sea. Right to haute pursuit. The general rule is that a country will have exclusive jurisdiction in the high sea over a vessel when it carries its flag. Haute pursuit is an exception to the exclusive jurisdiction of the flag state over a vessel in the high sea. If a foreign ship violates the law of the coastal state within its territorial waters, the coastal state can exercise right of haute pursuit. By virtue of the right of haute pursuit, men of war of a coastal state may pursue onto the open sea and seize and bring back into a port for trial any foreign merchantman that has violated the law at the time when it remained in the territorial waters of the state. The pursuit must be commenced when the foreign ship is within the territorial sea of the coastal state. Once the pursuit is begun, it should be uninterrupted. The pursuing ship should be government vessel. The pursuing vessel can arrest the foreign ship while it is in high sea. If the foreign ship has entered into the territorial waters of another country, the pursuing ship cannot arrest it. If the haute pursuit is wrongly exercised, the state will be liable to pay compensation. So that is with the law of seas under the public international law. There are the different zones of the maritime belt or territorial waters. Then we have contiguous zone. Then we have continental shelf. Then we have exclusive economic zone or patrimonial sea. And then we have the high seas. The next topic we have is state responsibility. State responsibility refers to the circumstance in which a state will be responsible to pay compensation for violation of rules of international law. The law relating to the state responsibility is in a developing state. Under the following circumstances, state responsibility arises and a state would be liable to pay compensation to the injured state. The first one, international delinquency. The expression international delinquency refers to every neglect of an international duty. International delinquency arises out of wrongs committed by a state. By wrong in this connection means the breach of some duty which is imposed upon a state under international law, which is not the breach of purely contractual obligation. If a citizen of a state causes damage or harm to an alien, that alien gets a right to file a suit for compensation according to the law of the state, of that state. In case the decision of the state is arbitrary and against justice, the alien may approach his home state to settle the matter through political means. Every state is under a responsibility to protect aliens who are permitted to come to a state. In case there is a failure on the part of a state to protect aliens, they would be liable to pay compensation. A state may also be held responsible for the harm caused to the aliens by mob violence. This responsibility arises only when the state has not made due diligence to prevent the mob violence. Humans Claim Case 1926. Humans Claim Case 1926, also known as USA versus Mexico. Here, the mayor of a town in Mexico ordered a lieutenant of the state force to proceed with troops to prevent riot against certain American citizens who have taken shelter in a house. The troop, on arriving at the scene of the riot, instead of preventing the riot, opened fire on the house in which Americans were taking refuge. Consequently, one of them was killed. The court held that the Mexican government is liable to pay compensation for the violation of their international duty. The responsibility of the state to protect aliens also extends to the officers or servants of international organizations. Another case, that is reparation of injuries suffered in the service of United Nations, 1948. In this case, Count Bernadotte, along with a French observer, was appointed by the United Nations Security Council to mediate in the conflict between Arab and Jews in Palestine. On September 17, 1948, when he and the French observer were in the area of Jerusalem occupied by Israel, they were murdered. The United Nations claimed compensation for the death of their servants. The ICJ held that UN is an international person and can claim compensation for injury suffered by the persons working under its service. The government of Israel paid the compensation. Now, the second scenario, that is after international delinquency, the other state responsibility is where responsibility for the expropriation of property of foreigners. If any state expropriates property of foreigners, state responsibility may arise. The foreigner who is aggrieved can claim compensation for the confiscation of his property. If the foreigner is not compensated or the expropriation was discriminatory, the state responsibility would rise. The third one is responsibility for breach of contract. A state may enter into contract with foreigners. The contract may be for the construction of building or to supply certain goods or services. If the state commits breach of contractual obligation, the foreigner can file a suit claiming compensation in the court in that state. The state in which the foreigner is a citizen cannot normally claim compensation for breach of contract. If the foreigner does not get compensation and justice from the municipal court, the state in which he is a citizen can claim compensation and the state responsibility would arise. Calvo Clause. Sometimes citizens of one state may agree with another state that in any matter arising out of that particular contract, they would not seek the assistance and protection of his state. Such a clause in the agreement is also known as Calvo Clause, named after the Argentinian jurist Carlos Calvo. Such clauses were frequently included in contracts between Central and South American government and foreign companies. According to this clause, the foreign companies holding concession or other grants could not invoke the intervention of diplomatic agents of their country. The foreign companies could only file suits in the municipal court of the state granting the concession. In a number of decisions, the Calvo Clause was held to be null and void. It is because an individual cannot contract out the right of the government to protect him. El Oro Mining and Railway Company Limited case, also known as Britain versus America. El Oro Mining and Railway Company Limited case, Britain versus America. In this case, the British Mexican General Claims Commission held the Calvo Clause as void. The British company had filed a suit against the Mexican government in a Mexican court claiming compensation for breach of contract. But 9 years have elapsed and without a hearing. The British government interfered and Claims Commission held that the Calvo Clause is void. North American Dredging Company case. In this case, the tribunal held that Calvo Clause, which prevent any diplomatic intervention, is invalid. So that is with state responsibility. The next topic we have is extradition and asylum. Asylum. A person may, after committing a crime in one country, escape to another country and seek asylum in that country for avoiding prosecution in the country in which he has committed crime. The Universal Declaration of Human Rights declares that everyone has a right to seek in other countries asylum from prosecution. Although everyone has the right to seek asylum, there is no corresponding duty on the state to grant asylum. The granting of asylum to a refugee is at the discretion of the state. The word asylum means giving shelter and active protection to a person who has committed crime in a foreign country and escaped to the country in which he is at present. There are different types of asylum. that is territorial asylum and extraterritorial or diplomatic asylum. Territorial asylum. Territorial asylum is granted by a state in its own territory. Territorial asylum is considered as attribute of territorial sovereignty of the state. Every state has a right to admit into its territory any person even though he has committed a crime in a foreign country. The grant of asylum to Dalai Lama and his followers is an example of the exercise of territorial sovereignty by India. Extraterritorial or diplomatic asylum. A state may grant asylum in its embassy in foreign countries or in its public vessel. Extraterritorial asylum can be classified into the following categories, that is, asylum in foreign legation, asylum in the premises of international institutions, then asylum in worship, and asylum in merchant vessel. So that is the four kinds of foreign extraterritorial asylum or diplomatic asylum. Asylum in foreign legation. As a general rule, asylum in foreign legation is not permitted. However, under certain exceptional circumstances, a state can grant asylum in its embassy premises in a foreign country. In view of this task, asylum may be granted in the legation premises under the following circumstances, and that is 3 circumstances. The first one, asylum may be granted for a temporary period to individuals who are physically in danger from mob violence or because of political corruption in the local state. The second one, asylum may be granted when there is a well-established binding local custom. The third one, asylum may be granted if there is a special treaty. Now, Haya de la Torre case. Haya de la Torre case, that is Colombia versus Peru in 1950. Haya de la Torre, a Peruvian citizen, was charged with rebellion. Colombia granted him asylum in her embassy in Peru. After granting asylum, Ambassador of Colombia requested Peruvian government to provide facility to enable Colombia to take Haya de la Torre outside Peru. Peru did not agree with the request and rejected it. Colombia contended that asylum was granted because Haya de la Torre was accused of political crime. The matter was referred to ICJ. The ICJ held that Haya de la Torre was a political offender and Colombia was not bound to surrender Haya de la Torre. There was irregularity in granting asylum because there was no urgency as prescribed by the Havana Convention of 1928. Then the second kind of extraterritorial asylum is asylum in premises of international institutions. There are no rules recognizing the authority of international organizations to grant asylum in the premises of the organization. However, temporary asylum may be granted in case of danger of imminent violence. Now, the third type of extraterritorial asylum is asylum in worship. There is a controversy in regard to granting of asylum in worship. Some writers are of the view that asylum can be granted in worship which is lying in the territorial waters of another state. Some writers have expressed the view that such fugitive should be immediately handed over to the local police. It is generally accepted that the asylum may be granted to political offenders whose life is at threat. The fourth kind of extraterritorial asylum, that is asylum in merchant vessels. Merchant vessels do not enjoy immunity and they are not competent to grant asylum to local offenders. Now, extradition. Extradition is the delivery of an accused or a convicted individual to the state in whose territory he is alleged to have committed a crime by a state on whose territory the criminal is found. Under international law, there is no duty of a state to extradite criminals. The obligation to extradite the criminal arises only when there is a bilateral treaty. So, essential conditions for extradition or restrictions on surrender. The first one, political crimes. Even though there is a bilateral treaty for extradition, persons accused of political crimes are not extradited. The practice of non-extradition of a political criminal began with the French Revolution of 1789. A leading case of non-extradition of political criminal is Re Castiglione. In this case, the Swiss government demanded extradition of a man named Castiglione. He was accused of murdering a member of the state council. An armed mob attacked the municipal place and killed the member of the state council. There was evidence that the shot had been fired by Castiglione. The Queen's Bench of England held that Castiglione had committed a political crime and therefore he could not be extradited. Another case is Re-Munier. Re-Munier, the accused was an anarchist and was charged with causing 2 explosions in Paris cafe. After committing the crime, he fled away to England. The French government requested for extradition. The accused contended that he cannot be extradited because he was accused of political crime. In this case, the accused did not belong to any political party. He was anarchist and was opposed to all sorts of political party or government. The court ordered for his extradition and held that there was no political crime. If the crime is committed for furtherance of political objectives, it will be a political crime. Now the second one is military crime. That is the essential conditions for extradition or restriction on surrender. The second one is military crime. Under international law, persons accused of military crimes will not be extradited. The third one is religious crime. Persons accused of religious crimes will not be extradited. Then the fourth one is double criminality. The specific offence for which the extradition is sought for must be an offence in the state requesting for extradition and the state in which the accused is found. Only if this test is satisfied, extradition can be ordered. This is called the rule of double criminality. The fifth one is rule of speciality. When an accused is extradited for an offence, the receiving state must try him only for that specific offence for which extradition was sought for. This is called rule of speciality. Then the sixth one is prima facie case. There should be sufficient evidence for the crime for which the extradition is requested, and it should be prima facie appear that the accused has committed the crime. There we have Tarasov extradition case of 1963. Tarasov extradition case of 1963. The court discharged a Soviet Union on the ground that there was no prima facie case against the fugitive criminal. Now the seventh one is extradition must be formally made. In order to be valid extradition, procedural formalities are to be followed. That is Savarkar's case of 1911. Savarkar was an Indian revolutionary who was being brought to India to be prosecuted. When the ship was in port of Marseilles, Savarkar escaped. He was arrested by French naval police and returned him to the captain of the British ship under the wrong impression that it was his duty to do so. Later on, the French government requested the British government to return Savarkar on the ground that the formalities regarding his extradition were not strictly observed. The Permanent Court of Arbitration held that there is no provision under international law imposing an obligation to return criminals who are once extradited even though the formalities are not followed. Then we have Sucha Singh's case. In Sucha Singh's case, Sucha Singh was accused of murder of Pratap Singh, the former Chief Minister of Punjab. He fled to Nepal. The government of India requested to the Nepalese government for his extradition. The government of Nepal started proceeding against Sucha Singh and after being satisfied that there was a prima facie case against him, extradited him to India. Then we have Dharam Teja's case. Dharam Teja was managing director of Jayant Shipping Corporation. He embezzled crores of rupees and fled away from India. When he was in Ivory Coast, the government of India requested for his extradition. The government of Ivory Coast refused extradition since there was no extradition treaty between Ivory Coast and the government of India. Later on, when Dharam Teja was in London, the government of India requested the British government to extradite him. The British government started the proceeding against him, and after being satisfied there was a prima facie case against him, extradited him to India. So that was with asylum, different types of asylum, extradition, and different kind of extraditions. The next topic we have is immunities and privileges of the sovereign and diplomatic agents. Foreign sovereign. A foreign sovereign enjoys absolute immunity from the civil and criminal jurisdiction of another state. A civil or criminal court of a country cannot exercise its jurisdiction against a foreign sovereign. A dispute regarding the property of a foreign sovereign cannot be decided by a court of another country. It is well established rule of public international law that a head of the sovereign state is immune from civil and criminal jurisdiction of another country. There is no limit with regard to the personal immunity of head of the sovereign state. If at all the head of the sovereign state has created an ordinary citizen, he can claim immunity. Mikhail versus Sultan of Johor. The Sultan of Johor went to England under a false name and acted there as an ordinary citizen of Johor. He fell in love with Mikhail and promised to marry her. Subsequently, he failed to act as per the terms of the contract. Mikhail filed a suit in England claiming compensation for breach of contract. At the time, Sultan claimed immunity from the jurisdiction of the court. The court dismissed the suit and granted immunity. Now, diplomatic agents, duties, immunities and privileges. Diplomatic agents are the persons who reside in foreign countries as representatives of the sending state. They act as a link between the sending state and receiving state. By virtue of the Vienna Convention on Diplomatic Relations 1961. Vienna Convention on Diplomatic Relations 1961, the diplomatic agents can be classified into following three categories. 1. Ambassador or nuncios and other heads of missions of equivalent rank. Second, envoys, ministers and internuncios. Then the third, charges d'affaires. Article 14, Clause 2 of Vienna Convention of Diplomatic Relations of 1961 provides that, apart from the precedence and etiquette, there is no difference between the diplomatic agents. The following are immunities and privileges of diplomatic agents. The first one, inviolability of persons of envoys. It is a well-established principle of international law that the persons of envoys is regarded as inviolable or not liable to search. Article 29 of Vienna Convention of Diplomatic Relations 1961 provides that the person of a diplomatic agent shall be inviolable. He shall not be liable to any form of arrest or detention. The receiving state shall treat him with due respect and shall take all appropriate steps to prevent any attack on this person, his freedom or dignity. Even though a diplomatic conduct is objectionable, or he is guilty of a crime, or he is alleged to have interfered in the internal matters of the receiving state, no arrest or detention can be effected. At the most, the received state can declare him persona non grata, that is, person non fit for this post, and ask him to leave the country within a specified time. The second one is immunity from criminal jurisdiction of the courts. The diplomatic agents are immune from criminal jurisdiction of the courts of the receiving state. If a criminal case is filed against a diplomatic agent in a court of receiving state, the agent who claims immunity can claim such immunity by sending a message to the court. He need not personally be present in the court and claim immunity. A diplomatic agent can waive his immunity. In such a case, he will be deemed to be within the jurisdiction of the court. The third one is immunity from civil jurisdiction. The diplomatic agents enjoy immunities from the jurisdiction of the civil court of the receiving state. Suits for recovery of debts, breach of contract, or for recovery of compensation for tort cannot be filed against diplomatic agents. Diplomatic agents enjoy civil and criminal immunity not only in the state in which they are appointed, but also in those states through which they pass to join their place of office and on the return journey. Now, Boraman's case. D was a French envoy for Bolivia. While he was going from France to Bolivia, he landed at New York. Then P started civil proceeding against him. D claimed diplomatic immunity. The court granted immunity and dismissed the suit. Article 31 of Vienna Convention on Diplomatic Relations recognized three exceptions to the rule of immunity from civil jurisdiction, and they are: 1. A real action relating to the private immovable property situated in the territory of receiving state is maintainable unless he holds the property on behalf of the sending state for the purpose of the mission. 2. An action relating to the succession in which the diplomatic agent is involved as executor, administrator, heir, or legatee, as a private person and not on behalf of the sending state. And the third one, an action relating to any professional or commercial activity exercised by a diplomatic agent in the receiving state outside his official function. In India, for filing suits against diplomatic agent of foreign states, consent of the central government is to be obtained, and that is discussed in section 86 of CPC 1908. Now the fourth one is immunity regarding residence. The residence of diplomatic agents are regarded as inviolable, that is not liable to be searched. Then the fifth one is immunity from compelling to be a witness. Diplomatic agents cannot be compelled to give evidence in the court as witness. A diplomatic agent may waive this immunity and may present himself in the court as a witness. And the sixth one is immunity from taxes. Under international law, the diplomatic agents are immune from payment of taxes in the receiving state. However, he will be liable to pay indirect taxes. Then eighth one, immunity from inspection of personal baggage. The personal baggage of the diplomatic agent is exempt from inspection. If there is doubt that it contains articles the import of which is prohibited by law of the receiving state, inspection can be conducted. The receiving state shall inspect the personal baggage only in the presence of diplomatic agent or his authorized agents. Now the eighth one is right to worship. Diplomatic agents enjoy the right to worship. They are free to follow any religion or perform the religious rituals and ceremonies in their own way. And the last one is right to travel freely in the territory of the receiving state. Diplomatic agents can travel freely in the territory of receiving state. However, they cannot go to the prohibited places or places which are important from the point of view of security of that state. Now, regarding duties of diplomatic agents, the following are the duties of diplomatic agents. 1. Diplomatic agents have a duty to respect laws and rules of receiving state. And 2. They have a duty not to interfere in the internal affairs of the state. 3. Premises of the mission should not be used in any manner incompatible with the function of the mission. And 4. Diplomatic agents could not practice for personal profits any professional and commercial activity. So that is with the immunities and privileges of the diplomats as well as who are foreign sovereign and diplomatic agents are. So that is the end of this part, and this is part 2 of Public International Law Exam Guide full series, and of total 4 parts. I hope this helps. If you like this, please click the like button, and if you are not subscribed yet, please do subscribe to my channel to support me. Thank you for listening and have a nice day.